Thanks, Jesse. Amanda, I think, are you gonna?
I'm working on it.
She's working. Well, she's gonna share her screen so we can get the PowerPoint going. It's our pleasure to be with you all this morning. Of course, we'd hoped to be in person, like we were able to do a couple years ago, but COVID didn't want to cooperate, and so we'll do kind of the best we can virtually. Our topic for this morning is what's next: information blocking compliance. This is a 2-hour presentation, and we'll see if we get kicked out at an hour, or in that time period, we'll make sure to try to take a break. So our agenda, I think, Amanda, are you still kind of trying to get it?
Yeah.
Okay, there we go.
There we go. Okay.
So to start with our agenda this morning, these are generally the topics that we plan to discuss with respect to the information blocking rule. We're going to give just a brief refresher of the overview, kind of, what is the information blocking rule, where did it come from, where we're at. We're going to go through some scenarios with respect to is it or isn't it information blocking. We're going to talk about HIPAA versus information blocking. As we go through our information blocking discussion this morning, you'll notice there are some similarities where information blocking is kind of piggybacking off HIPAA, and in other places there are some differences, and we're going to kind of walk you through those so that you'll be able to recognize that in your organizations. And then the last part of the presentation will be focusing on specific areas where we're seeing a lot of questions surrounding the information blocking rule with respect to the use of patient portals, lab results, draft notes, and then paper records. So just briefly to remind us kind of where this came from. So the information blocking rule came from the 21st Century Cures Act, and so that was in 2016. And the stated requirements of that legislation was that the Office of the National Coordinator was tasked with putting forth rulemaking to implement the information blocking rule. And ONC decided that it would be a good idea to drop that rulemaking on May 1st, 2020, in the middle of the COVID pandemic. So it kind of snuck up on us. The other piece of the legislation tasked the Office of Inspector General with investigating potential violations of the information blocking rule. There are penalties that we'll talk about if you do violate the information blocking rule. And then also Congress tasked ONC with setting up a compliance or a complaint process that if you feel a person or entity believes that they're a victim of information blocking, a complaint process to follow. So the kind of one of the stated purposes of the legislation is that the intent is to improve coordination within the healthcare system and patients' access to their health data. And so we've been watching this since 2016, and Amanda and I regularly advise clients with respect to HIPAA and patient requests for records and access. And all along in working with clients, Amanda and I kind of thought, well, is there really a problem? Is there really an issue with patients getting access to their data? This is one of the stated purposes of the legislation, but do patients really have trouble getting access? And Amanda and I, working with clients, to us, it's a resounding no. We work with hospitals, we work with clinics and practices and physicians. And in our experience, providers are giving access to patients to the information. But maybe there is a problem here. We just, in the last month or so, the Office for Civil Rights just settled its 19th patient access case since it started its patient access initiative in 2019. So maybe there is a problem that needs to be fixed. But let's first talk about, what information blocking means. And so this is, unless there's a requirement by law that access not be provided, or that there's an exception that applies, it's a practice that's likely to interfere with the access, exchange, or use of electronic health information. And all these terms interfere with access, exchange, use EHI are all defined terms that we're going to walk you through this morning. The second bullet there talks about health IT developers, health information networks, health information exchanges. So this rule applies to those entities as well. But the last bullet is really what is most important for most of you on the call this morning, which is because you are all healthcare providers. So it's information blocking, unless it's, there's an exception or it's required by law, if it's conducted by a healthcare provider and such provider knows that such practice is unreasonable and is likely to interfere with, prevent, or materially discourage access, exchange, or EHI. Now, what's important about that definition is the knowledge standard. As many of you know, there's lots of regulations out there, Stark, for example, that are not intent-based. It's just strict liability. If you violate it, you violate it. Here, information blocking, it is not strict liability. So it is intent-based, which does provide providers with a little bit of protection so that if you are in a situation where there's an allegation of information blocking, if you can show that there wasn't any kind of intent, that could be a defense. If we move to the next slide, Amanda, please. So here's kind of the key elements of information blocking that we're going to walk through this morning. So first, you actually have to be an actor covered by the information blocking rule. Spoiler alert, healthcare providers are covered. So there's not a whole lot to discuss with respect to that item. It has to involve electronic health information, and EHI is specifically defined under the rule. So it has to be EHI for this to apply. The practice has to be one that's likely to interfere with, prevent, or materially discourage access, exchange, or use of EHI. You have to have the intent, the requisite knowledge that you are trying to actually block somebody from getting access to the information. The information blocking cannot be required by law, and then it's a situation where there may not be an exception that applies. So with that, Amanda, I think I'll turn it over to you to have you start walking us through those 7 or 6 elements.
Yes, thank you, Brooke, and good morning, everybody. So the information blocking rule contains many definitions, and several which are somewhat different than those of us that are well educated in HIPAA would know them to be. So as much as the HIPAA and the information blocking rule are somewhat intertwined because they are going to be dealing with the same type of information, the definitions are different. And when we're walking through these analyses or analyzing whether or not a code of conduct or a policy interferes with requests for information, we have to pay attention to the definitions. And so the first element is that the actor is regulated by the information blocking rule. The actor has to be a healthcare provider, health IT developer of certified health IT, and health information network and health information exchanges. Originally in the information blocking rule, to the extent any of you followed the rule from its beginning to end, we started out with 4 different definitions. Ultimately, the ONC combined health information network and health information exchanges into one character or one group of actor, so that to try and simplify things. But ultimately, these are the 3 different types of actors that are going to be governed by the information blocking rule. As Brooke mentioned, spoiler alert, healthcare providers are the big, probably group of people on this call, and also the group of people that are going to be most impacted by this rule. And what the ONC did was adopt the definition of healthcare provider at 42 U.S.C. 300JJ3. And that essentially includes every single healthcare provider out there: hospital, nursing home, community mental health center, your individual practitioners, and then there's always the catch-all at the very end of any other category of healthcare facility, entity, practitioner, or clinician determined to be appropriate by the secretary. So ultimately, if you provide healthcare services, you're going to be covered by this rule, and just, I guess, accept it, move on with be prepared. And so then the second type of actor is a health IT developer of certified health ID. This was a very, very broad definition to begin with, and ONC really kind of carved it down with the final rule to expressly exclude self-developers of health IT for their own use. They are no longer covered by the definition of health IT developers of certified health IT, and really made it essentially an individual or entity that develops or offers health information, which at the time it engages in the practice, it is the subject of that engages in the practice that is the subject of an information blocking claim. It owns or operates or offers one or more health IT modules that are certified by the ONC. The idea here is that this doesn't extend beyond the time the developer no longer has that health IT certified under the program. So it's really trying to just cover those health IT developers that are using that. They are engaging in practices that interfere with the exchange, use, or access of health IT when they're going to be governed by the information blocking rule. Then you have the health information networks and exchanges. This is, again, what they did was combine and narrow these definitions and really revised them to specifically be a health information network or health information exchange. To be one of those, there must be more than 2 unaffiliated individuals or identities that are enabled to exchange with each other. The idea here and the reason why you've got to have the more than 2 unaffiliated individuals is they wanted to ensure that this definition is not going to cover essentially bilateral exchanges where you're simply performing a service on behalf of one entity and exchanging information, and there's no actual exchange between multiple entities. They also limited this definition that the exchange of information is for a treatment, payment, or healthcare operation purpose. For those of us that are educated in HIPAA, that's very, very familiar to us, and they actually adopted the treatment, payment, and healthcare operation terms as defined in HIPAA. And so they tried to narrow this a little bit more because there was some fear that it would cover absolutely everybody, and made it more about the exchange under exchange for treatment, payment, and healthcare operations between 2 or more unaffiliated individuals or entities. Element number 2 of the information blocking rule is that the request for access, exchange, or use involves electronic health information. This is a very key definition and really important to any information blocking analysis. Electronic health information, as defined under the information blocking rule, is electronic protected health information, as defined in HIPAA, to the extent that that EPHI would be included in a designated record set. And what the ONC did was essentially adopt, again, HIPAA's definition of electronic protected health information. They adopted HIPAA's definition of designated record set. And so you're really looking at that EPHI and this idea that you should not have to separate electronic health information from EPHI to comply with both HIPAA and information blocking. The ONC recognized that would be very difficult for providers to do. So they tried to align these definitions as much as possible, but they do use electronic protected health information as the definition here. And 2, they also carved out, much like HIPAA's definition of PHI, they carved out psychotherapy notes as defined under HIPAA or information compiled in reasonable anticipation of or use in civil, criminal, or administrative actions and proceedings.
Hey, Amanda, before you move on, I think we may have somebody that's not on mute, so we're getting a little bit of background. So if we can make sure everybody's on mute. And then I just had a couple additional comments on the health, the electronic health information and specifically designated record set. Just as a reminder, designated record set, I mean, that's really the patient's medical, the medical records, the billing records, really any records that are used in whole or in part that are used to frame the medical decision making with respect to the patient. we're not talking about records that aren't really tied to patient care. So we're not talking about your quality records, your risk management records, your peer review records, your business system records. None of that type should be maintained in your designated record set anyways. But I think with the information blocking rule, it gives us an opportunity to go back and take a look at what we are including in our designated record set to make sure we're including appropriate records, not only from a HIPAA standpoint, but also from an information blocking standpoint.
And in light of, I think, the volume of records that the information blocking rule covers, ONC is giving, I think they call it giving the providers a break or an adjustment period in dealing with this, but essentially from April 5th, which was the date of the effective date of the information blocking rule, until October 6th of 2022, EHI is limited to the data elements represented in the U.S.C standard. And so essentially, if it's something that falls outside of those U.S.C standards, which we'll get into a little bit in a minute, it is not covered by the information blocking rule. You can interfere or deny the access, exchange, or use of that information and not be in violation of the information blocking rule. But starting on October 6th, 2022, the actor must respond with all EHI that is covered in the definition and not limit it to that U.S.C standard. Again, it's this idea that it should help with compliance and not be overly burdensome. But I think we're also going to see that they will, if you can provide all EHI in response to a request now, they're going to want you to do that and provide as much EHI as you can. A couple of other things to remember: de-identified data is not electronic health information, and as Brooke alluded to, to the extent that you have price information in your in your designated record set, or it is somehow included in that information, it is health information. It's in the designated record set. It is going to be considered to be EHI. Now, if it is kept separately from your designated record set, it would not be considered to be health information and not part of the EHI. So it's really looking at what's in that designated record set, what's in that information. And so some providers might want to look closely at where you do keep your price information. As I mentioned, for the next essentially 22 months after the effective date of the rule, so until October 6th of 2022, we're really looking at requests for information that include the data elements and data classes of the U.S.C standard. I took some of the big primary ones from the website here, but as you can see, it covers a lot of information, and a lot of information that may not currently be in a patient portal. You're looking at your all the various different levels of your clinical notes, problems, procedures, smoking status. The unique device identifiers for patients' implantable devices are considered to be a data element of the U.S.C standard. All of the demographic information, all of the vital signs. So you really want to take a look at this U.S.C and get a good feel for all the information contained in that as far as the data elements, because that's how electronic health information is going to be defined going forward, or at least for the next little over a year and a month or two. Element number 3 is that the practice or policy, if you will, is likely to interfere with, prevent, or materially discourage access, exchange, or use of electronic health information. The rule defines interference with or interfere with or interference, which is an action that means to prevent, materially discourage, or otherwise inhibit. It is a practice essentially also of showing delay of access, exchange, or use. So you cannot unreasonably delay in responding to an access, exchange, or use. And we'll get into some discussion of the interplay between HIPAA and the information blocking rule later. But this gets into this idea that while HIPAA allows you to spend 30 days responding to a request for access, if you could respond tomorrow and you wait until the 29th day to respond, that may be a process of slowing or delaying access and a violation of the information blocking rule. According to the final rule, excuse me, this the reason for kind of the broader definition here is they want there to be careful consideration of the individual facts and circumstances in considering whether or not a practice interferes with a response to a request for access or exchange. So they do really want any consideration, any examination of an actor's practices to be very fact specific. But the issue for us in trying to help for compliance and for analyzing practices is it leaves us with this very broad, uncertain area of how to comply, because it is going to be based on the individual facts and circumstances. And that then gets into this idea that if you do have a practice that interferes with access, exchange, or use, you want to make sure you document everything so that you can have that individual facts and circumstances analysis. Another part of this element 3 definition is that it's a practice that interferes with the access, exchange, or use. Access, exchange, and use are all defined, and they are slightly different than the definitions for access and use in HIPAA. Access is the ability, and two, they're all closely related concepts. You can't really consider one without the other, because EHI cannot be used unless it can be accessed. And this often requires that the EHI be exchanged among different individuals or entities through various technology means. So they all kind of interplay and work together. Access is the ability or means necessary to make EHI available in exchange or use. Exchange means the actual transmission between or among different technologies, and it doesn't have to be just a one-way for it to fall into this category. And then use is the ability, once it's accessed or changed, to be understood and acted upon. And the ONC was very clear on this use, because I think a lot of people were concerned about how they defined it. This does not mean that you provide additional resources or any type of key to interpret the records. And the example that they use is that if a hospital has a certain risk score that they have in the record, the hospital doesn't need to provide additional resources to interpret that risk score, or if you use certain abbreviations, you don't necessarily have to provide that. But the idea that you can't just send over an encrypted file and not send over the decryption key, you need to be able, or the receiver needs to be able to understand and read essentially that information that is sent over. Interoperability element. This is a definition related to the licensing exception, which is one of the exceptions that we will walk through in this presentation. But it is essentially the type of devices or information that is governed under this information blocking rule, and it's that hardware, software technologies that are related to the licensing and privileges that may be necessary to access the information or are controlled by the actor. And again, this definition is something that they're going to allow a licensing exception, that you can license certain health IT or that might interfere with the access, because they understand people want to develop technologies. You may want to profit off that, and there's a recognition that you should be allowed to reasonably profit off of interoperability elements that you develop.
So Amanda, just one thing on the interoperability element. So what this is getting at, correct me if I'm wrong, this is related to if there is a software or a hardware or some sort of technology that is needed in order to be able to use the EHI. You kind of did a spoiler alert that there's an exception, licensing exception that you could actually license that technology in order for somebody to read it. So if you had, I don't know, radiology images or something like that, and it required a special reader technology for someone to look at it, perhaps the licensing exception would enable you to license that technology in order to be able to allow them to read it. Is that what we're getting at with this one?
Yeah, that's what we're getting at here, and it's the idea that again, you're going to have to meet the various different elements of the licensing exception, which requires an agreement, that it's reasonable, that the terms are reasonable and negotiated. So if you have any of these interoperability elements, like some sort of reading device for radiology, that you do have to meet all the elements of the licensing exception, but you can enter into some sort of agreement. You can interfere with the access, exchange, or use because you have the software, you've developed the software, and that is going to be okay, and you're not going to be in violation of the information blocking rule. So element number 5 of the information blocking rule is that it's an interfere or access, exchange, or use of EHI that is explicitly required by state or federal law. The idea between the required by law, and this was a point of big emphasis with the ONC, is that there are interferences that are required by law, and then there are ones that are often engaged in pursuant to a privacy law, but they're not required. It gets into this idea of must versus may. You may disclose information versus you must disclose information, which will be a theme throughout our presentation today. But the idea is that if a law prohibits disclosure of information that you can interfere with, you can deny access to that information because it is required by law. And we have some examples as we get into our information blocking analysis of how this particular part of the analysis and exception works. The final element, the 6th element, is that an actor will not be engaging in information blocking if the practice reads a regulatory exception. The ONC defined 8 different regulatory exceptions as part of the final rule, and they categorized the 8 exceptions into 2 different categories. One category is the exceptions that involve not fulfilling requests, so when you can deny or interfere with a request for access, exchange, or use and not be in violation of the information blocking rule. And then the second category is an exception that involves fulfilling requests, but maybe not fulfilling requests as requested, or the fact that you could charge fees is that second one. So the idea was this should offer certainty that when your practices or your policies with respect to accessing, exchanging, or using meet one of these definitions, you as an actor can take, feel comfortable with the fact that it's not considered information blocking. I'm not sure that even with these definitions, we've reached any type of comfort level with that yet, but that's what the ONC was trying to do in outlining these exceptions. Essentially, if your practice does not meet one of these exceptions, and you're interfering with the access, exchange, or use of electronic health information, it will not automatically constitute information blocking. That's an important thing to remember here. It's just that it's going to be evaluated on a case-by-case basis. It's going to be looked at as to whether or not the practice was reasonable. Did you have the knowledge standard? And so, you don't. It's important to try and find, if you're going to deny a request for access, exchange, or use, it will be good practice to try and fit it into one of these exceptions, so you get some of that certainty. But again, there are other ways to evaluate your practices. So we're still waiting on some clarity on the penalties involved with a violation of the information blocking rule. We do know that there will be civil monetary penalties involved at this point for health IT developers and health information networks. Those right now, the proposed rule provides civil monetary penalties of up to $1 million per violation. For healthcare providers, they're still seeking, the OIG is still seeking feedback on that. They really have no civil monetary penalty authority, so they didn't outline a potential authority, but the idea is potentially referring to appropriate agencies for disincentives, which could result in other penalties or disenrollment from Medicare Medicaid programs. And so there's still a lot of uncertainty as to how how someone or how an actor will be penalized for a violation of the information blocking rule.
All right.
So
go ahead.
I was going to say, with that overview, I'm going to turn it over to Brooke for some walking through how we analyze all this.
Great. So we're going to walk through the various exceptions and talk through some scenarios that will hopefully illustrate each part. Amanda and I have presented, in the last year or so on information blocking multiple times, and we understand it's a very dense subject. So we've tried to create this flow chart that you see that will help you follow the presentation as we analyze each one of the scenarios, but also would be a helpful tool for you to use to take back to your organization when you're having to work through this process. So the first step is figuring out, do we have electronic health information? So is the request a request for electronic health information, or if it's paper? I mean, if it's just paper, then okay, nope. And we just proceed with our HIPAA privacy analysis related to disclosures and access, just like we would normally do. If the answer is yes, that it is a request for electronic health information, then you have to move to the next step. And that's the required by law analysis. Is there a statute? Is there a regulation that says, we must deny access, exchange, or use of this information? If the answer is yes, you just deny, you document what law, what statute, what regulation, and you deny access and you move on. If there isn't a law or regulation that would require you to deny access, you then have to move to the next step, which is a review of those exceptions that Amanda walked us through on the previous slides. If one of the exceptions applies, one of the first 5 exceptions, which is a flat out, you don't disclose, you deny the request. Again, all of this is documented to move on. If one of those doesn't apply, then you want to look at the other 3 exceptions Amanda discussed with respect to the content and manner of the licensing, the fees, to see if you produce, but maybe not quite in the manner that's been requested. All right, next slide. So the first, I just mentioned, the first step would be to determine whether electronic health information is involved or not. The next slide. Step 2 would be the required by law analysis that I mentioned. Step 3. Oh, we got it. Sorry, we got it. We've got a HIPAA. We've got a hypo here. So let's go to the next slide. So we put together this analysis, or this hypo, to highlight the required by law exception. So here's the scenario. We've got Josh. He's got West Health Insurance. He visited his PCP and paid for the visit out of pocket. He requested that his primary care provider restrict disclosure of his health information to his insurance company. He did not want that information to go there. West Health has requested a copy of Josh's electronic health information, from his PCP. Can the primary care provider deny access? And here, this should sound familiar to you that are familiar with HIPAA, is that under HIPAA, patients have the right to request restrictions on the disclosures of their protected health information. And that includes to their insurance company if the patient actually pays out of pocket. So here we actually have a required by law, per that HIPAA regulation, the primary care provider can deny access because the patient has a right to request restrictions on disclosures of their protected health information. I think we've got another example that highlights this required by law exception as well. Here, we've got Zoe, who's a minor. She recently visited a clinic for diagnosis and treatment of venereal disease. Her parents subsequently reach out to the clinic, inquiring about her visit and requesting a copy of Zoe's medical records. So here, the first step would be it just says medical records. So the first step is, we have to make sure they're asking for it in an electronic health information. If no, then it's step 1 and you do your typical HIPAA privacy analysis. But let's assume for purposes of this hypo that they are requesting electronic health information. So we moved from the step 1 to step 2. So the question becomes, is there something in a statute, in a regulation, that would prevent the clinic from sharing that information with Zoe's parents? And the answer would be yes. Under Missouri law, because a minor can consent to obtain treatment for venereal disease, then they have the ability to control, who has access to that information. So here, if it really becomes a judgment for the physician on, whether it would be beneficial in his or her opinion for that information to be disclosed to the parents without the consent of the minor. All right, step 3, we are moving on to the 5 exceptions that are flat out. If you meet these exceptions, you may deny access, exchange, or use of the protected health information. And I think Amanda's going to talk us through a couple of those exceptions.
Right. So again, as Brooke was, walking us through the analysis, you were first going to look at whether or not it involves electronic health information. If it does, is it required? Is a restriction required by law? This now we're moving on to, there's no law that governs denial of access. So we move down on to step 3, and there's those 5 exceptions. And so we want to start walking through and looking through each one of those exceptions and whether or not the interference or denial of access meets one of those exceptions. And the first one that we usually look at is the preventing harm exception, or will the access, exchange, or use reasonably result in harm to a patient or another person? If we can answer yes to this question, then we can deny the request for access. So what does the preventing harm exception entail? Well, it's that you can engage in a practice that is reasonable and necessary to prevent physical harm to the patient or another person. There's several parts of this preventing harm exception that you must meet to qualify for this exception. And those different parts are that you must have a reasonable belief that the practice will substantially reduce the risk of harm. That practice can be absolutely no broader than necessary. They want it to be as limited as possible. That practice must satisfy at least one condition from each of the following categories: type of risk, type of harm, and implementation bias. And we'll walk through each one of those. And then the practice must satisfy a condition concerning the patient's right to request review. Under HIPAA, and HIPAA has a preventing harm exception under it as well. And what the ONC did is align this, as they aligned it with HIPAA, is what they did in the final rule. And under that final rule, and under HIPAA, the patient has the right to request review if you deny on the basis of preventing harm. And so in this, if you invoke this exception, the patient still has the right to request review of the reasons why you interfered with or denied the access on the basis of preventing harm. So again, you have to meet one of the types of risk, and so that the risk must be determined on an individualized basis. So again, we're working on our individualized basis here. We've got to document that if we're going to do it, but it's the professional judgment by a licensed healthcare professional with a clinician-patient relationship. So you have to have that established patient relationship that can make a determination on an individualized basis that there's going to be a type of a risk of harm. The other type of risk can be one that arises from data that is known or reasonably suspected to be misidentified, mismatched, corrupt, or erroneous. So the idea is if there's information in there that is incorrect or erroneous or identified with the wrong patient, you can deny access because it would cause harm in providing that type of data. There's the type of harm that you have to meet a type of harm which is individual to the or danger to the individual's life or safety, or when the EHI references another person or personal representative requests access, that access is reasonably likely to cause substantial harm. What they did was pick up the exact same harm standard in the HIPAA privacy rule for preventing harm and dropped it into the information blocking rule. So for those of us that are familiar with that preventing harm piece of the privacy rule, same thing here, same analysis, same standards.
Amanda, if you just back up just a second. So an example you related to that second bullet with the EHI referencing another person or personal representative. I mean, and that could be a situation where maybe child abuse is suspected. The child has made certain disclosures to their healthcare provider. The healthcare provider documents it in the record. Now the parent is requesting a copy of those records. To me, that example kind of illustrates what they're getting at with respect to this preventing harm exception. Would you agree?
I would. Yep, that's what they're getting at. Yep, that's exactly what they are getting at there. So then the final part that you also have to meet is that there's some sort of implementation bias or basis. And that's either going to be an organizational policy or a determination that is specific to the facts and circumstances. If you have an organizational policy on this preventing harm exception, it needs to be in writing based on relevant clinical, technical, or other appropriate expertise and consistently applied in a non-discriminatory manner. We are always going to recommend that you have some sort of organizational policy that outlines these various analyses and requirements, because it's much easier than making sure you've got all your ducks in a row in the documentation if you fall into the latter category. But the latter category is a catch-all, so to speak, that if you don't have an organizational policy, or if it's just certainly an unusual facts or circumstances, that you can invoke this exception based on the facts and circumstances that are known, and based on the expertise in implementing the exception, and be sure that you have documented all the facts and circumstances as to how you meet the type of risk, the type of harm, and all the factors considered when you're going to deny a request for access based on the preventing harm exception. So again, I think with some of these exceptions, one of the easiest ways to maybe understand them a little bit better is with our hypotheticals. And so we have one here for you. Again, we're going back to Zoe, who's a minor. She recently visited the clinic for a diagnosis of treatment of a venereal disease, and her parents contact the clinic inquiring about her recent visit, trying to figure out why she was there, and requesting her medical records. As we discussed before, medical records is kind of bland. So if it's paper records, you still keep paper records, then that's not going to be something that's not EPHI. It's not going to be electronic health information. So you would engage in your normal HIPAA analysis. Assuming that it's electronic protected health information, moving on to required by law, the denial isn't necessarily required by law. So can the clinic deny access to Zoe's medical records to her parents? Well, one might think it would be incredibly mortifying for a minor's parents to find out that she came to visit the clinic for treatment of a venereal disease. But the preventing harm exception can only be used if there's a reasonable belief that interfering with her parents' access would substantially reduce the risk of substantial harm. So we can't speculate that, oh, well, it's just going to be awful for her parent to know that their daughter was treated or sought treatment for venereal disease. We have to have that reasonable belief and that knowledge that it will substantially reduce the risk of harm. The other idea is too that this risk of harm is defined as life or physical safety, and so emotional harm does not fall into this. So the fact that someone might be emotionally traumatized by her parents finding out would not meet that life or physical safety piece of it. But if we change the facts a little bit, and let's say there's a clinician and patient relationship, and that clinician knows that Zoe has also sought treatment for domestic abuse. Her one of her parents has regularly abused her, and yet she still lives with them. And they know that her parents would have a tendency to do that upon finding out this particular type of information. The clinician then could choose to not release any test results, not release her information, and plan to deliver that information in a more secure and safe manner. And that's where the preventing harm exception might apply in this case, because the clinician reasonably believes, based on the relationship with the particular patient, that in the clinician's best judgment, the restriction is reasonably necessary to prevent physical harm to Zoe. So it's really a fact-based circumstance when it comes to preventing harm. To give you another example of preventing harm, and this is dealing more with the corrupted information, we have Jed, who recently visited the hospital after a bicycle accident. He was prescribed a muscle relaxer. His primary care physician requested his medical records from the hospital. During the export of his records, it shows no current medications in the medication section. The hospital knows that this is an error because his muscle relaxer prescription is still current. Could the hospital deny the primary care physician's request? Under these facts, they could, because the preventing harm exception. There's that risk of harm to the patient that arises from knowledge that there's corrupt or erroneous information. It's the idea that it may be vitally important for the primary care physician to know about the muscle relaxers. It may interplay with something else that the primary care physician is treating Jeb for. But we'll get into the content and manner exception and later in this presentation. But when you're looking at this, you do want to consider whether or not there's a different method for satisfying the request. Would it be easier to fax the records? Let's say you print them and it actually shows up. So maybe you need to fax the paper records over, or follow up with a supplement of the prescription information, or call the primary care physician and explain that the no current medications is inaccurate. So there you do want to kind of look at, are there other ways of satisfying the request by when a request comes in, but there's a reason for not providing the information as requested.
All right, so the next exception we're going to take a look at would be the privacy exception. And as we're walking through these 5 exceptions, you don't have to walk through them in the order that we are. There's not really a right or wrong reason on how you go through them. We've just ordered them this way for purposes of our presentation. So privacy exceptions, the next one we're going to walk through. And it has a lot of similarities with respect to HIPAA and the privacy exceptions under HIPAA. So first off, the actor, the healthcare provider, in our case, must be engaged in a practice that's intended to protect the privacy of electronic health information. So that's where our intent needs to lie, that this practice, we're trying to protect privacy. The actor must also satisfy at least one of the following. So we'll talk about each one of these. The precondition is not satisfied. So this could be some sort of regulatory precondition that needs to be satisfied before access can be granted. The next one applies with respect to health IT developers of certified IT not being covered by HIPAA. There's a denial of access request from the individual that they don't want their information disclosed. And the last one kind of goes hand in hand with respect to an individual that's given a signal on what their preferred privacy preferences are. So let's walk through each one of those. So precondition not satisfied. The best example I can provide here relates to state and federal requirements that may require a patient consent or a patient authorization, written authorization, be signed by the patient before information is disclosed. Going back to Amanda's comments about organizational policies and procedures, here's another example of where we would recommend having a policy and procedure with respect to the privacy exception and how you evaluate those within your organization. If you're in a situation where you believe that you need the patient authorization, then you need to make sure that you take steps to obtain the patient's authorization before the information is disclosed. Next slide. Denial of an individual's request might be consistent with the right to access. So This tracks with HIPAA. Under HIPAA, a patient does not have a right to access two categories of information, one being psychotherapy notes. And as we all know, psychotherapy notes is a very limited category of protected health information. It's not all mental health or behavioral health notes. It's essentially the therapist personal notes with respect to the therapist decision making and thinking with respect to the patient that falls into this category. And then the second category of information would be information that's compiled in anticipation of litigation, a judicial proceeding. Both of those categories are not subject to access. There's also, under the information blocking rule, certain categories related to research and other sources of information that you can deny. And the last bullet pertains to information that's obtained from non-healthcare providers that is provided pursuant to a promise of maintaining that information confidentially. The last item here would be respecting an individual's right not to share information. Ultimately, patients have a right to control access to their information. And if they don't want you to disclose their information or grant somebody else access to it, they have a right to direct that. Now, the important thing is that under the information blocking rule, it's made clear that a provider cannot encourage or induce a patient to deny granting access to a request for information. So as a provider, you can't go to a patient and say, you really shouldn't sign this authorization. You shouldn't, that's your information. You shouldn't disclose it. That would be, may be considered information blocking. Now, you can obviously educate patients on their rights, and Amanda will talk about that a little bit more in the presentation, but you don't want to do anything that would be considered to be an improper encouragement or inducement by the patient to deny access. All right, next slide, Amanda, please. So here is our example, still sticking with Zoe with the basic fact pattern that we discussed before with respect to her treatment and her parents asking for access to her electronic health information. Here, this you can see that this fact pattern, we've got the required by law would be a potential, opportunity not to grant access. We have the preventing harm potential here, and we also have the privacy exception. She does not want us to share that information, and under state law, she has a right to consent to that treatment. This would be an appropriate exception to rely on to not share that information with her parents. And then the next one, and this one to me is very important because we see it a lot. Hospitals, clinics, physicians, you receive subpoenas for medical records all the time. Sometimes it's from law firms, sometimes it's work comp, sometimes it might be some other type of malpractice type litigation, but you receive these subpoenas, and sometimes they come with an authorization, and sometimes they don't. For purposes of our fact pattern, the hospital did receive a subpoena and included an authorization that was signed by Sam. So what do you do? Should the hospital respond to the subpoena? As Amanda mentioned earlier, HIPAA has not gone away. So we still have to go through the HIPAA analysis. And so here we have to look at, does the authorization meet the HIPAA requirements? And if yes, it contains all the valid requirements of HIPAA, then you respond to the subpoena with the medical records. If no, and this is really, to me, a take-home point, what the information blocking rule requires is for you to make a reasonable effort to get that a satisfactory authorization signed by the patient. And to me, this is a change. So, prior to information blocking, advising clients if they got a subpoena and it didn't have an authorization or the authorization didn't meet requirements, what I would tell them to do is, send a note back to the attorney, whoever sent the subpoena, and say, this is not compliant with HIPAA. You need to get me an authorization that complies with HIPAA. You need to get me a court order. We're not turning over the records. To me, HIPAA didn't put it on the provider to go out and try to get that authorization. We've got a fundamental change here with the information blocking rule, which says, you provider, if you don't think that authorization meets the HIPAA requirements, you have an obligation to try to get a satisfactory authorization form. So this could be you providers sending your standard HIPAA authorization to the patient and saying, hey, sign this. We got this authorization from your attorney, but it's missing one of the requirements. If you want us to send the records, please sign this. There is a little bit of a proactive effort that a provider is now obligated to do to get that authorization signed. Now, the rule also says you don't have to chase patients to try to get them to sign authorizations. So if you reach out to a patient and they don't respond or they tell you no, then I think you fulfilled your obligation. But the important thing here, the takeaway here, is you can't just kind of act like we used to, in the sense, and put it back on the individual that was subpoenaing the information.
Brooke, can I ask a question on this?
Sure.
If the hospital or provider standard practice used to be, regardless of whether there was an authorization attached to a subpoena, the response was, we want it on our authorization. We aren't going to honor the subpoena until somebody signs our authorization. Do you think that's a reasonable response to a subpoena if that authorization that originally came with the subpoena contained all the HIPAA requirements?
That's a great question. I mean, personally, I think there's some risk from an information blocking standpoint if you were to take that stance. I mean, if you get an authorization and it contains all the elements, then I think you should just honor it and produce the records. If your standard policy was that we don't disclose records unless it's on our HIPAA authorization, I think you might be opening it yourself up a bit to a potential claim of information blocking, because you were presented with one that contained all of the elements, and it's just your preference that it's on the hospital or clinic form. Good question. All right, so then the next exception we want to talk about would be the security exception. And again, we've got the flow chart. This is still in step 3. The question is, will the access, exchange, or use compromise the security of electronic health information? The answer is yes. Then we can deny the request for access, exchange, or use, subject to maybe one of the manner and format exceptions that we'll talk about later. So the actor, the intent, the measure must be to protect the security of electronic health information. So it can't be that you're just trying to keep somebody from accessing their information. There really has to be an intent, a measure, a protocol in place to protect the security of the electronic health information. The threshold conditions related to this exception, really there's 3 pieces to that. So the practice must be directly related to safeguarding the confidentiality, integrity, and availability of electronic health information. Confidentiality, integrity, and availability should sound familiar. HIPAA security rule, those are the 3 components of the HIPAA security rule that are repeated throughout the security rule with respect to electronic protected health information. So that those concepts have been adopted as part of the information blocking security exception. The practice needs to be tailored to the specific security risk. To me, this is the focus from an information blocking standpoint, as Amanda mentioned earlier, is to be very limited. So if there's a more limited, a more tailored protocol measure that we can put in place to address that security risk, then that is what the provider, the actor, needs to do. And again, the common thread through all of these exceptions is that they need to be implemented in a consistent and non-discriminatory manner. So you can't treat patients differently than their personal representatives, or you can't treat patients differently than other providers. It has to be a consistent approach across the board. And when you think of it from a security standpoint, if the motivation is really to protect the security of information, I mean, that has to apply across the board anyways. I mean, if it's really going to be a legitimate security issue. And then again, we recommend implementing an organizational security policy and a qualifying security determination. The nice thing here is that another way of saying organizational security policy is HIPAA security policies. And another way of saying qualifying security determination is your security HIPAA security risk assessment. So if you've got HIPAA security policies in place and you're doing your HIPAA security risk assessments, you're probably covering this. Now, you may need to make a few tweaks to those security policies just to bring in references to the information blocking exception. But by and large, if you've got those HIPAA security policies in place and you've been doing your risk assessments, you've already done a lot of the legwork with respect to supporting from a documentation standpoint. If you want to rely on the security exception. Organizational security policies, these probably sound kind of common sense. We recommend it to be in writing. I mean, some people have informal unwritten policies, and I mean, those are difficult to follow, and even more difficult if there's a complaint to say, well, our policy and the person is just supposed to, or the government agency is just supposed to take it on trust that you had this policy in place. So have it in writing. It needs to be based on the security risks that are identified and assessed as part of that risk assessment policy. A good rule of thumb, and I think most of us dealing with that have dealt with the HIPAA security rule since it was implemented in 2005, we look to industry standards, we look to best practices, and so if the best practice is not to grant access via a particular protocol software, or not to grant access via a particular device. If that's a industry best practice, then that's something that should be documented. Qualifying security determination. Again, this is kind of your risk assessment, having it, going through the assessment and then coming up with the action item to mitigate that security risk. And if there's really a situation that there's just no reasonable or appropriate alternative, make sure that's documented, that just under no situation could we ever allow a third-party application access. We could never send the electronic health information to it because it's just, it's considered unsafe, it's been hacked, whatever it is. There's just, we just can't use it. Make sure that's documented. All right, so let's run through a security exception. So here we have a hospital that's noticed an increase in the number of unauthorized attempts to access its EHR. So maybe these are the thousands and millions of pings we get each day, but they went from 100,000 a day to a million. So they recognize that there's a risk and that somebody is potentially trying to compromise their EHR. So they shut down remote access to the EHR. And this is in part to try to figure out, do we have an issue? Do we have a security issue? Local physician would normally access the records via that remote access to view records of his or her patients. And Abby wants that remote access. So the question is, can the hospital delay or deny Abby's access, like she normally would have remotely to the EHR? And here, I think this is a great use of the security exception. We've got a situation where we may be vulnerable and we need time to figure out if this is something internal. Is it potentially, is Abby the security risk? A lot of times it's those outside providers who are linking in to your EHR that could be the security issue. I literally had a situation with the client within the last few months, which is, that's exactly what happened. That the hacker started with one entity and used that connection to get to the other hospital. So here, I think it's appropriate to delay as long as we're doing that to mitigate the security risk. We couldn't delay or deny our access forever, but at least until we've had a chance to investigate. Reasonable alternatives. That goes to that form and format exception that Amanda's alluded to. That we'll print them off, Abby, and fax you a copy. Abby, we'll print them off, next time you're in the hospital, if you want to swing by HIM and pick up a copy. So there's other ways that we could get her access to the records that she needs aside from the remote access while we're kind of, trying to work through the potential security situation.
And with the security exception, I think there was some idea or some discussion in the final rule that there is the ability for this initial response to be drastic, to shut down all remote access, to kind of shut down some of that people's ability to maybe access the information because our risk assessment or our risks are certainly high, and especially today where we're seeing a lot of cyber security attacks. So there was this idea in the information blocking rule and the final rule that if you're going to invoke the security exception and you have that security risk assessment and you're trying to assess the current risk, your initial response can be drastic. However, once you kind of get that assessing the current risk, looking into it, you may want to replace, and the ONC is going to expect you to replace that initial drastic response with a less onerous response that is reasonably and appropriately tailored to that risk. So your security exception and ONC's idea behind the security exception is that it will potentially evolve over time. You're going to need to either grant Abby access back, maybe give her a different remote login if there were issues there, and really look at that delay or denial of access over time.
Amanda, I've noticed